5 seconds to go. Start. This is because in the absence of proof of demand, a legal presumption under Section 20 of the Prevention of Corruption Act 1988, for short the Act, would not arise. Thus, the proof of demand is a sine qua non for an offence to be established under Section 7, 13(1)(d) 1 and 2 of the Act, and d-horse the proof of demand, the offence under the two sections cannot be brought home. Thus, mere acceptance of any amount allegedly by way of illegal gratification or recovery thereof in the absence of proof of demand would not be sufficient to bring home the charge under sections 7, 13(1)(d) 1 and 2 of the Act. Hence, the pertinent question is as to how demand could be proved in the absence of any direct evidence being let in by the complainant owing to the complainant not supporting the complaint or turning hostile, or the complainant not being available on account of his death or for any other reason. In this regard, it is necessary to discuss the relevant sections of the Evidence Act before answering the question for reference. Before proceeding further, it would be useful to refer to the relevant provisions of the Act. Sections 7, 13(1)(d) 1 and 2 and 20 of the Act as they stood prior to their amendments are extracted as under. Public servant taking gratification other than legal remuneration in respect of an official act. Whoever being or expecting to be a public servant accepts or obtains or agrees to accept or attempts to obtain from any person for himself or for any other person any gratification whatever other than legal remuneration as a motive or reward for doing or forbearing to do any official act, or for showing or forbearing to show in the exercise of his official functions favor or disfavor to any person, or for rendering or attempting to render any service or disservice to any person with the central government or any state government or parliament or the legislature of any state, or with any local authority, corporation or government company referred to in clause C of section 2, or with any public servant, whether named or otherwise, shall be punishable with imprisonment, which shall be not less than 6 months, but which may extend to 7 years, and shall also be liable to fine. If a person not expecting to be in office obtains a gratification by deceiving others into a belief that he is about to be in office and that he will then serve them, he may be guilty of cheating, but he is not guilty of the offence defined in this section. The word gratification is not restricted to pecuniary gratifications or to gratifications estimable in money. The words legal remuneration are not restricted to remuneration which a public servant can lawfully demand, but include all remuneration which he is permitted by the government or the organization which he serves to accept. A person who receives a gratification as a motive or reward for doing what he does not intend or is not in a position to do or has not done comes within this expression. Where a public servant induces a person erroneously to believe that his influence with the government has obtained a title for that person, and thus induces that person to give the public servant money or any other gratification as a reward for this service, the public servant has committed an offence under this section. A public servant is said to commit the offence of criminal misconduct by corrupt or illegal means obtains for himself or for any other person any valuable thing or pecuniary advantage, or by abusing his position as a public servant obtains for himself or for any other person any valuable thing or pecuniary advantage, or while holding office as a public servant obtains for any person any valuable thing or pecuniary advantage without any public interest. For the purposes of this section, known sources of income means income received from any lawful source, and such receipt has been intimated in accordance with the provisions of any law, rules, or orders for the time being applicable to a public servant. Where in any trial of an offence punishable under section 7 or section 11 or clause A or clause B of subsection 1 of section 13, it is proved that an accused person has accepted or obtained or has agreed to accept or attempted to obtain for himself or for any other person any gratification other than legal remuneration or any valuable thing from any person, it shall be presumed, unless the contrary is proved, that he accepted or obtained or agreed to accept or attempted to obtain that gratification or that valuable thing, as the case may be, as a motive or reward such as is mentioned in section 7, or as the case may be, without consideration or for a consideration which he knows to be inadequate. Stop.